As Attorney General, I am required by law to defend the state in habeas cases, and I don't have the luxury of picking which cases to defend. Should a public official begin picking and choosing which laws to enforce, such actions would undermine the very foundation of our system of government. When Genarlow Wilson was convicted of aggravated child molestation, the law required him to receive at least a 10-year sentence for his crime. The state legislature could retroactively reduce this sentencing requirement, or the Georgia Supreme Court could rule the sentence unconstitutionally harsh. The Attorney General can do neither. The press and Wilson's attorneys have focused on Judge Wilson's attempts to impose a misdemeanor sentence on Genarlow Wilson. The unbroken and uncontradicted line of cases from both Georgia appellate courts, however, clearly holds that a habeas court has absolutely no authority to reduce or modify the original sentence of the trial court. Moreover, there are over 1,300 inmates in the Georgia prison system currently serving time for aggravated child molestation, and this ruling, if unappealed, would have the potential to reduce or set aside the sentences of a significant number of those convicted felons, as well as potentially allowing convicted child molesters released from prison to avoid having to register on the state's sex offender registry. Less than 2 days after the ruling, my office received a habeas filing in another case that attempts to cite Judge Wilson's erroneous ruling as legal authority for an inmate's release. I have an obligation under the law, as well as a significant concern for the decision's broader impact on public safety, to appeal the ruling. In light of the 2006 legislative changes making this conduct a misdemeanor for future offenses, I personally believe that the mandatory 10-year sentence for Genarlow Wilson is harsh, but my personal beliefs do not control my public duty. It is the Georgia Supreme Court that must decide whether Wilson's original sentence is now unconstitutional. While this matter is on appeal, I personally would not oppose bond for Mr. Wilson, but that is a matter between Wilson's attorneys, the Douglas County District Attorney, and the trial judge. The District Attorney has offered Wilson's attorneys a plea opportunity that would result in a lesser sentence and the possibility of first offender treatment, which would mean no criminal record and no sex offender registration upon completion of his probation. Wilson's attorneys have rejected those offers. Nevertheless, this office will continue to lend its support, where appropriate, in reaching some finality to this case. At the end of the day, my job is to follow the law and to see that it is applied fairly and consistently to all.
What you've just heard is a statement by the Attorney General for the state of Georgia, Thurbert Baker, explaining his rationale, at least, for why he is appealing the judge's decision in the state of Georgia to free Genarlow Wilson.